Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Live Law. We bring you the latest and in-depth legal coverage, coming to you with a brief of what all happened in the Indian courts today. Starting with the Supreme Court, which today declined the urgent listing of a plea challenging the internet shutdown in the state of Manipur. The internet ban has been continuing in the state since 3rd of May. The plea challenging this was mentioned before a vacation bench comprising Justice Aniruddha Bose and Justice Rajesh Bindal today. However, noting that the matter was already ongoing before the High Court of Manipur, the vacation bench declined to urgently list the matter and asked the council to mention it before the regular court. You already know that the internet shutdown was imposed in the state after riots were triggered due to a direction of the Manipur High Court to consider the inclusion of Meitei community in the scheduled tribe list. The Supreme Court today modified the Delhi High Court order, which granted 15 days of interim bail to YSRCP MP Magunta Srinivasulu's son, Mugunta Raghav Reddy. While the vacation bench did not cancel the bail granted to Reddy, it asked him to surrender on 12th of June. The bench opined that the purpose for which Reddy was released on interim bail was to take care of his maternal grandmother who had slipped and was now in the ICU. This purpose could be served by June 12th, and so he could surrender then. Reddy, as you know, was arrested by the Enforcement Directorate in February this year in connection with the Delhi liquor policy scam. In another update, the Supreme Court today directed the Madras High Court administration to submit through its Registrar General a detailed report on the issue of lack of toilet complexes for women lawyers in the Nilgiris court complex. As you know, recently the National Commission for Women, acting on a complaint filed by a lawyer, had urged the Madras High Court registrar to take immediate cognizance of the lack of toilets for female lawyers. Today, the Supreme Court bench noted that while the Registrar General had earlier filed a report in the matter, that report did not explain in detail in what manner the facilities for women lawyers were being provided and whether there was any shrinkage of such facilities which were earlier available. The court has asked for the detailed report to be submitted by this Sunday, that is 11th of June. The Supreme Court today listed for June 13th the special leave petition filed against the Telangana High Court order, which had granted anticipatory bail to the Kadapa MP Y.S. Avinash Reddy in Vivekanand Reddy murder case. The petition has been filed by Sunitha Reddy, the daughter of deceased Y.S. Vivekanand Reddy. The matter was mentioned before a vacation bench comprising Justice Aniruddha Bose and Justice Rajesh Bindal by senior advocate Siddharth Luthra, who argued that High Court had passed the order on basis of media reports. Stay tuned for further developments in the case. The Supreme Court today rejected the third mentioning made by advocate Ashwini Upadhyay seeking urgent listing for his petition challenging RBI and SBI's notifications that permit exchange of rupees 2000 currency notes without requirement of any identity proof. The Supreme Court vacation bench pointed out that last week another bench had already passed an order refusing urgent listing of the matter during vacations. The present bench said that it cannot modify the order passed by a coordinate bench. In another update, the Supreme Court today sought the centre's response in a plea challenging Delhi High Court's order, which had allowed bike taxi aggregators Rapido and Uber to operate bike taxis without aggregator licenses till a final policy regarding it was notified. The Supreme Court bench was hearing a special leave petition filed by the Delhi government challenging the High Court's order, which stayed the notices issued against Rapido and Uber. In February, the Delhi Transport Department issued a public notice to stop plying bike taxi services effective immediately. But in May, the Delhi High Court, while issuing notice to the Delhi government on Rapido's plea, directed that no coercive action be taken against the bike taxi aggregator till a final policy has been notified. The Supreme Court also declined the urgent listing of plea of Payal Maheshwari, wife of alleged gangster Sanjeev Maheshwari Jiva, seeking a no coercive action order so that she could attend her deceased husband's post-funeral rites. State of UP, represented by Additional Advocate General Garima Prasad, informed the court that Jiva's funeral had already taken place yesterday, and the petitioner Payal Maheshwari did not attend the funeral even though she was allowed, and the police had ensured that no coercive action would be taken against her while she is attending the funeral. The court said there seemed no urgency for the matter to be heard by the vacation bench. The Kerala High Court today closed the petition filed by a lawyer seeking 1 crore compensation for the bereaved family members of the 23-year-old house surgeon Dr. Vandana Das, who, as you know, was brutally killed by an injured man brought to the government hospital in police custody. The division bench, comprising Justice Devan Ramchandran and Justice Kausar Edappagat, today took note of the government order sanctioning rupees 25 lakhs to the parents of the deceased. The bench orally added that no amount of money could compensate for human life. The Kerala High Court today dismissed the petition filed by Advocate Yashwant Shenoy, who alleged that a sitting judge had limited the number of cases listed before the bench to only 20 matters a day. The court termed it a publicity interested litigation to malign judges and the judiciary. The lawyer had moved the court, alleging that Justice Mary Joseph was limiting the list of cases before her court. The Chief Justice being the master of roster, Justice Joseph had no power to direct the registry to curtail the list. A single judge bench of Justice P.V. Kunnikrishnan observed that the Court of Justice Mary Joseph, being a hearing court, could not be compared to that of an admission court. An admission court may be handling more than 100 admissions a day, but that does not mean a judge considering hearings can consider the same. The first appeal in criminal and civil matters, being a continuation of the trial, is bound to take time. Similarly, second appeal in civil matters and criminal revisions against conviction and sentence will also take time to dispose of. In another update, some of the candidates of the 2023 Civil Services Examination have challenged the qualifying Part 3 CSAT exam conducted by UPSC last month and have asked the Central Administrative Tribunal to direct the Commission to reduce the cutoff for Paper 2 or to conduct a re-exam. The candidates alleged that the difficulty level of the questions was similar to those asked in CAT and IIT JEE examinations. The plea argues that though UPSC has a discretion in setting the question paper, but the same cannot be immune from judicial review if it is otherwise discriminatory, arbitrary, and falls foul of the Constitution. The matter is listed tomorrow before the principal bench of the Central Administrative Tribunal. Stay tuned. And now coming to an update on the matter related to Prime Minister Narendra Modi's degree. In 2016, the Central Information Commission, CIC, had directed the Gujarat University to provide information regarding degrees in the name of Mr. Narendra Damodar Das Modi to Delhi Chief Minister Arvind Kejriwal. The university filed an appeal regarding this, and the Gujarat High Court quashed the order of CIC on March 31st this year. Now, the Chief Minister Arvind Kejriwal has moved the Gujarat High Court seeking a review of this March 31st order. Admitting the matter today, the bench of Justice Biren Vaishnav issued a rule to the respondents, Gujarat University, the Chief Information Commissioner, and the Union of India. In his review plea, Kejriwal has submitted that while the court, in its March 31st order, based on submissions made by Solicitor General Tushar Mehta, had noted that PM Modi's educational degree is available on Gujarat University's website, however, the plea adds the same is not available. Only an offline register is available on the website, which is different from the degree. The matter has been posted for hearing on June 30th. We will keep you updated with the further developments. The Calcutta High Court has made it clear that while it is essential to eliminate dummy accounts allegedly benefiting from Centre's Manrega scheme, it is also the duty of the government to ensure that genuine workers do not suffer the brunt of it. The case relates to the issue of pending wages of daily wage workers in West Bengal. In March 2022, the centre stopped release of funds under the scheme and directed that wages will be paid by the state government from its own resources till it submits a satisfactory action taken report regarding the use of funds. The petitioners, who claim to be workers under the scheme, say that they have not received their wages since December 2021. The division bench, comprising Chief Justice T.S. Sivangnanam and Justice Hirannamai Bhattacharya, called upon the state government to answer whether such a redressal mechanism has been established for dealing with any complaint in respect of implementation of the scheme, and whether any procedure has been laid down for disposal of such complaint. The court has listed the matter for further hearing in July. And lastly, the Gujarat High Court has allowed the termination of over 20 weeks old pregnancy of a minor rape victim and said that the medical procedure be undertaken at the earliest possible time, considering the mental and physical health of the 17-year-old victim girl. The victim, through her father, had filed a petition seeking the termination of the pregnancy. In connection with the rape, a FIR stands registered. She also prayed for DNA sample preservation in the case. Following the court's order, the victim was examined by a panel of doctors, and it was recommended that the procedure be carried out as soon as possible to avoid further complications associated with advancing gestational age. The bench of Justice Samir J. Dave said that any decision regarding medical termination of pregnancy depends upon the facts and circumstances of each case. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us.